California has trapped itself, as I see it, in the large capacity magazine ban case of Duncan versus Bonta, using something, ready for this, folks, called Corpus Linguistics. That's right, Corpus Linguistics has trapped California. Stay tuned, I'll explain to you all when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We really would appreciate the support. And thank you all again for helping us hit the 100,000 subscriber mark. I really appreciate that. We'll talk more about that in a few days. Okay, guys. Wow. So I continue to read through the papers submitted by the state of California in the case of Duncan versus Bonta, which is how they're trying to justify banning magazines, standard capacity magazines that hold more than 10 rounds, which they label with political propaganda phrases like large capacity magazines, which of course they're just standard capacity magazines that hold more than 10 rounds. And there's something that caught my eye on page 6 of California's brief to justify it. It's a discussion of something called Corpus Linguistics. Corpus Linguistics. Now, I know what you're thinking. You're thinking like, Mark, what on earth is Corpus Linguistics? Well, the good news is you're asking that question of the right person because you're talking to the person that wrote a 100+ page article on why Corpus Linguistics should not be used in Second Amendment cases, which I will link to down below. So you are indeed talking to the right person about how anti-gunners and people that support gun control regulations, generally speaking, like the notion of corpus linguistics. Let me explain. In 2008, the United States Supreme Court heard a case called Heller versus the District of Columbia. Obviously, the right to keep and bear arms was vindicated in all respects, and that Justice Scalia's opinion says you have a right to a handgun loaded and unlocked in your home under the Second Amendment's right to keep and bear arms. There was a brief or a series of arguments submitted in Heller in the form of amicus briefs, which is friend of the court briefs, by linguists, arguing that if you go back in time to the founding era and you count up the number of words and do other sort of a linguistic analyses, that the proper way to interpret the words to bear arms or bearing arms, things like that, was that it involved a military context. Because if you may recall, the Heller case was about whether or not the right to keep and bear arms protected your right as an individual American, my right as an individual American, or whether or not it protected some sort of a militia right or a military right that says that we don't have an individual right to keep and bear arms. That right belongs to some government agency like the National Guard or the military or whatnot. Okay, the Supreme Court rightly and clearly rejected that and said that the right to keep and bear arms, just like the rest of the rights articulated by and codified by the Bill of Rights, deals with individual rights and not some sort of collective right or militia right or military right. But the linguists in that case, linguists made arguments that the proper way to interpret the Second Amendment was that it was more of a collective right or a military right, and it wasn't an individual right. Justice Scalia in Heller specifically repudiated this argument and said, no, it's not true. It's an individual right. The linguist arguments made about the text of the Second Amendment is not correct as we see it, and therefore it's rejected. So fast forward to the last few years, specifically the years leading up to NYSERPA versus Bruin, which, as you know, in June of 2022 was a major Supreme Court decision that says that we have a right to bear arms, which means to carry guns outside the home loaded in anticipation of self-defense. That's what, again, Heller was about the right to have a gun in the home, and the Bruin was about the right to have a gun outside in public for the purposes of self-defense. The right to keep was Heller, and the right to bear was Bruin. With that said, there was a series of briefs and arguments made using a theory, a very academic theory, a very geeky theory called corpus linguistics. Now, corpus linguistics sounds hard to understand, but it's really not. And I'm going to explain to you why it's not that hard to understand. Corpus linguistics is two words. The word corpus means body, and the word linguistics means language. So the words corpus linguistics, which is Latin for body of words or body of language, is what we're talking about here. Now, the way the methodology of corpus linguistics works, at the end of the day, is word counts. And the reason why I'm telling you this now is because California is specifically using corpus linguistics to try to justify taking away your right to keep and bear arms in California in federal court. So I want you to at least have a basic understanding of corpus linguistics because California is using it as a weapon in court to take away your rights. That's how I see it. So you need to know at least a little bit something about this. You don't have to read my 100-page article on this. It will. I would not. I love you guys too much to assign this work to you. So do not read my article unless you are a glutton for punishment. It's an extremely important article. In fact, it was cited by lawyers in NYSERPA versus Bruin to the United States Supreme Court, and obviously it prevailed. Implicitly, because the corpus linguistics theory that was argued in NYSERPA versus Bruin that basically was against our side as a general matter was obviously rejected because the Supreme Court came out to the right answer in NYSERPA versus Bruin. So I think my scholarship was important, although we never know exactly what makes a decision at the Supreme Court level. But let's carry on. So corpus linguistics is basically a way, and what's happened is that certain scholars go back in time to the founding era, and then what they do is they count up words. So they'll count up the number of times the word arms appears in the military context versus the number of times, let's say, arms appears in the civilian context, or they count up words, or they do some sort of other word count using these computerized databases. Now, I, in my article on corpus linguistics, raised real questions about the trustworthiness of databases because, as you know, once you put data into databases, to search them, you have to be very sensitive about the possibility of bias in them, the possibility they could be manipulated in some way. So remember, your output when you search a database is only as good as what's in the database. And I flagged issues about this as to why I thought corpus linguistics is really not appropriate for the purposes of interpreting the Second Amendment specifically. So corpus linguistics, as used by California specifically, is trying to say that based on word interpretation or word usage at the time of our founding, the word magazine was not considered an arm. And specifically what California argues in their brief, and I'll read it to you, and I'll put a link to their brief down below. It's on page 6. California says that box magazines, right, the magazines with more than 10 rounds are not arms under the plain text of the right to keep and bear arms. And as a consequence, and this is what they write, quote, "This conclusion is supported by corpus linguistics analysis." That's right. This conclusion is supported by corpus linguistics analysis. Historically, the term arms refer to, quote, weapons such as swords, knives, rifles, and pistols, close quote, and did not include accoutrements like, quote, ammunition, containers, flints, scabbards, holsters, or parts of weapons, period, close quote. They cite to a decision, I think out of the Rhode Island called Ocean State, that's crediting the testimony of a corpus linguistics professor who's quite well known in the field. And that's what they talk about on page 6. So here's my point, though. So that's how they're using corpus linguistics to try to say that magazines are not arms. Magazines are not protected by the text of the Second Amendment. Therefore, they don't have to shift the burden to the government to come forth with historical analogs to justify the banning of these magazines that hold more than 10 rounds. Now, this is clearly a problematic argument for the anti-gun side as I see it. And I'm going to tell you why right here and right now. Number one of the things that the corpus linguistics analysis has apparently provided, according to the citation, is that it includes ammunition as something that would not be protected by the Second Amendment, not a protected arm. And here's the killer. This is why it's a trap, and California has made a mistake here, in my view, and trapped themselves. Because they've laid out that among other things that are not protected by the Second Amendment's definition of arms, using corpus linguistics analysis, is ammunition. This is killer for California, because apparently no one connected the dots of a decision by the Ninth Circuit Court of Appeals, which is the appellate court, the federal appellate court that oversees cases like Duncan versus Bonta and the work of Judge Benitez and other lower courts. Because if they had gone back to the year of our Lord 2014 and read the case of Jackson versus the city and county of San Francisco, the Ninth Circuit decision 2014, they would have found that, guess what, is protected by the Second Amendment. According to the Ninth Circuit, which is binding Superior Court precedent on district court judges like Judge Benitez. This is what the Ninth Circuit said. They said that ammunition is protected by the Second Amendment. Ready? Here's the quote from the Ninth Circuit. Quote, "The Second Circuit protects arms, weapons, and firearms. It does not explicitly protect ammunition. Nevertheless, without bullets, the right to bear arms would be meaningless. A regulation eliminating a person's ability to obtain or use ammunition could thereby make it impossible to use firearms for the core purpose." Then it cites to Heller and goes on to say, and the Ninth Circuit continues on to say, quote, "Thus the right to possess firearms for protection implies a corresponding right to obtain the bullets necessary to use them, period." And then it cites to some other authority. Do you see what just happened here and how California has just trapped themselves? California is bound by this Ninth Circuit decision that says ammunition is protected under the right of the people to keep and bear arms. That is binding legal precedent. Okay? But here you have them citing to Corpus Linguistics analysis on page 6, where they're basically saying that magazines are akin to ammunition in the sense that both fall within the founding era definition of accoutrements and therefore are not protected by the Second Amendment. But the problem, of course, as you quickly can tell, is that by putting ammunition in the same bucket of items as magazines and vice versa, they basically are now pointing out that magazines would be equally protected as ammunition is under the Ninth Circuit precedent of Jackson. So I'm not sure what happened here and why California didn't connect those dots. Maybe they did and they didn't care and they ran the argument anyway. But as I see it, it looks like this is almost a concession that magazines are protected arms just like ammunition, which of course makes sense. So let's go beyond corpus linguistics, which again, I don't think is a credible way to interpret the Second Amendment, because just counting up the number of words is not a replacement for studying the philosophical, the history, the legal analysis of our founding era, just by doing a word count and searching a computerized database and counting up words as to what they meant in 1791. Set aside, of course, the fact that detachable box magazines don't even technically exist until the late 19th century, which means if you're doing a word count or analysis of a linguistics database from the founding era for, let's say, looking up AR-15s or AK-47s, guess what? You're not going to find those there either, because they didn't exist, just like detachable box magazines didn't exist until after the founding. But it doesn't matter. Why doesn't it matter? You know why it doesn't matter. Because the Supreme Court in Heller and the Supreme Court in Caetano says that modern firearms, including semi-automatic pistols, that's Sam Alito's, Justice Alito's words, not mine, including semi-automatic pistols in Caetano, are protected arms. We're not limited to muskets and dueling pistols and so on at the time of the founding. We're entitled to modern firearms in the same way we're also under the First Amendment entitled to use pens, paper, ink, printing presses, the internet, phones, and television, and so on and so on and so on. Just because those are modern inventions doesn't mean we don't get to use them to advance our First Amendment rights. So too, as the Supreme Court is reporting out repeatedly, we get modern firearms, including semi-automatics. And as you know, what is an essential component of an essential component of a semi-automatic firearm is obviously a magazine. Right? Many of these cannot fire without a magazine, and it certainly cannot fire more than one round without magazines. And therefore, it's necessarily implicated by the text of the Second Amendment. Remember, the way this works as a methodology is you have to show that the plain text is implicated. A ban on any type of magazine, including those that hold more than 10 rounds, is implicated by the plain text of the right of the people to keep and bear arms shall not be infringed. The word arms necessarily implicates certain things like ammunition, which the Jackson case in the Ninth Circuit teaches us. It also necessarily implicates things like barrels, right? Barrels are needed for firearms. Well, you can't ban barrels because it's a part. You can't ban magazines if it's a part, because these are all necessarily implicated by the text of the word arms. You can't have arms that function without barrels, magazines, and so on and whatnot. So again, the bottom line is this, that California on page 6 is trying to use this theory of corpus linguistics. It should not work for the 100+ pages of reasons I articulated in my argument in my law review article a couple years ago that was cited to the U.S. Supreme Court, by the way, in Neisser versus Bruin. For all the reasons I've articulated there, corpus linguistics should not work to be used to apply and interpret the Second Amendment. Beyond that, even if you assume for the sake of argument that it works in the context of the largest capacity magazine ban case in Duncan versus Bonta, it actually, and my argument is it backfires on California because it puts within the bucket of things that are not protected by the text of the Second Amendment, ammunition and magazines, which, as you know, the Ninth Circuit has already said that ammunition and things like ammunition are protected because they're necessary for arms to function, for firearms to function. And of course, we know there's Supreme Court precedent that says modern firearms, such as semi-automatic pistols and the like, are also protected arms, which all require magazines to function and or for magazines to allow those firearms to fire more than one round without the need to reload. Okay, folks, I hope you learned a little bit something about corpus linguistics. I apologize for having to talk about this very geeky topic, but because California is trying to use corpus linguistics analysis to take away your right to keep and bear arms, specifically to deny you the ability to have magazines that hold more than 10 rounds, I thought it was essential that I at least bring it to your attention and flag the issue for you. And again, if you want to learn more about the doctrine of corpus linguistics and why it doesn't work in the context of interpreting our Second Amendment, the Second Amendment, and protecting our Second Amendment rights, feel free to check out the link to my big law review article that goes on for hundreds, over 100 pages of detailed analysis. You can check that out if you're a glutton for punishment, but you don't need to, but you can. And again, if you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.